Good morning and welcome to today's webinar. My name is Beth Mandel. I'm a Senior Managing Associate in the Employee Benefits and Executive Compensation Practice Group of Thompson Hine Cincinnati office. I'm joined today by Thompson Hine Associate Mark Kroboth from our Cleveland office. And today Mark and I will examine a number of new group health plan requirements that flow from the Consolidated Appropriations Act and the price transparency regulations adopted under the ACA. Issues we'll address include new health plan price transparency disclosure requirements, prescription drug reporting, broker consultant fee disclosures, and then new written analyses required in connection with mental health parity. This webinar today is presented in partnership with Professional Group Plans. Our goal is to arm you with the knowledge that you'll need to help your employer clients to navigate these new requirements. And today's presentation is being recorded, so if anyone wants a recording, you can contact Professional Group Plans. The recording probably will not be available until a few days after the presentation. During today's presentation, please feel free to use the question box in the control panel at the upper right-hand corner of your screen. We'll answer questions in the middle and at the end of the webinar as time permits. And I'm gonna get things started now by turning things over to Mark.
Thanks, Beth. So as Beth mentioned, I am going to talk about some of the new transparency requirements that were enacted through the Consolidated Appropriations Act and that stem from the Transparency and Coverage Final Rule. And the first requirement that I'm going to be talking about is the requirement to provide machine readable files. And the original due date for providing these machine readable files as finalized in the Transparency and Coverage Final Rule was January 1, 2022. Group health plans were responsible to make publicly available 3 different machine readable files, one for in-network amounts, one for out-of-network amounts, also called allowed amounts, and then a third file for prescription drugs. And in August of 2021, Affordable Care Act Implementation FAQ 49 was released. And with regard to machine readable files, it essentially did 2 things. So the first thing it did was it delayed the prescription drug file requirement. And the reason it did this is because the Consolidated Appropriations Act also has a prescription drug reporting requirement, and I will speak to that a little bit later. So to not have those 2 be in conflict with each other, the prescription drug file is delayed pending further guidance. And then secondly, it delayed the implementation date of the in-network and out-of-network files to July 1st, 2022, or if later, the first day of the month of the plan year, if your plan year starts after July. So if you have an October 1 plan year, you're not going to be responsible to provide these files until October 1st. So what information is going to be required in these files? For the in-network file, you're going to have to include the health insurance oversight numbers. This could be a 14-digit HIOS number or a 5-digit HIOS number. And if you don't have one, then it's going to be the employer's EIN. Second, you're going to have to include billing codes, which identify the healthcare item or services for the purpose of billing, adjudicating claims, and paying claims. Some examples are CPT codes, healthcare common procedure coding system, diagnosis related group codes, and you also need to include a plain language description for each of the codes. And then the third thing is what's maybe most important is the applicable rates. And so a lot of in-network structures have various different rates. So you're going to have to include negotiated rates, underlying fee schedule rates, or derived amounts, whichever apply to the plan and the in-network providers. The amounts must be reflected as dollar amounts with respect to each covered item or service furnished by an in-network provider. And the rates will have to include national provider identifier, tax identification number, and place of service codes for each in-network provider. So the out-of-network files you're going to have to include the same identifying information as the in-network files, and you're going to have to include the same billing code information. However, because there's not going to be any applicable rates that are predetermined, you're going to have to include allowed amounts and billed charges for all services provided by out-of-network providers during the 90-day time period that begins 180 days prior to the publication date of the file. So for example, if you do have a calendar year plan and your requirement starts on July 1st, you're gonna have to go back 180 days, and then at the 90-day period beginning on that day is what the file is gonna have to contain. And then as I stated earlier, the prescription drug file, we're not gonna be discussing what needs to be in that today because it has been delayed. So a couple additional considerations that are important. The aggregation of data is permitted for out-of-network amounts. So if a TPA is taking these amounts, they're going to be able to aggregate them and provide them together in a single file. And then secondly, for in-network information, not only is there no aggregation, but you or a TPA is going to have to provide the information for each coverage option under a plan. So for example, a lot of plans will have 2, 3, maybe 4 different coverage options, HMO or PPO, and maybe a high deductible option. Each one of those options will have to have its own separate in-network file. So this information is not going to be readily available for group health plans. So they're really going to have to lean on their TPAs or their insurers to comply with the orders. So it's a really good idea. Ideally, these conversations have already taken place with TPA, since for a vast majority of the plans, the obligation is going to start next month. So you want to amend services agreements, have conversations with their TPAs to see what services they can provide in terms of complying with this requirement. For self-insured plans that contract with a third-party TPA, they're not going to be able to shift any liability. So for example, if the TPA just completely altogether neglects to do this, or if the information is incorrect, the liability won't shift. Whereas for a fully insured plan, fully insured plans will be able to contract with their insurers to shift liability. So it's very important. It's very important for both fully insured and self-insured plans to have agreements, but it's particularly important that fully insured plans are entering into written agreements with their insurers to document that the insurer is going to take care of this requirement. So where do the files go? You're going to be able to house the files. You're going to have to house the files on a public website. And a lot of these files, the TPAs are going to house them on their website and provide plans with a link to place somewhere so that the information can be accessed. I think there's been a lot of discussion about where the link must go or where you're going to be posting these files. I think ideally you want to be able to post them on a public website of the plan, but also I think it's important to recognize that most plans probably don't have a public website. And if they do have a website, it's usually behind a credentialed a wall where you need to enter a username and password, and the final rule specifically states that that is not permissible. These need to be publicly available, no passwords, no no paywalls. It needs to be able to be searched by a search engine, searched and found by a search engine. And I think the reason for that is that the information is not going to be for plan participants. It's going to be for researchers and data analysts to quote, help drive additional price comparison and consumerism in the health market. So the format, the machine readable files, as I said, they must be publicly accessible. And the format as listed in the final rule, these are just open source data files such as JSON, XML, or CSV. If you have an Excel spreadsheet or a PDF file, those are not going to be compliant with the requirements. Out-of-network files are going to be updated. Well, they're both going to need to be updated on a monthly basis. more than likely, there's a chance that the in-network file might be similar from month to month, but the out-of-network file is likely to change drastically because that 90-day period that I mentioned earlier will be changing each month. So plans will not fail to comply if there are errors and omissions, as long as the information is corrected as soon as possible. They will also not fail to comply if the internet website is temporarily unavailable. Obviously the regulators understand websites go down. And then third, they will not fail to comply as long as there's a good faith reliance that the information provided by a third party is correct, unless it is known that the information is inaccurate. So I think at this point, in the perfect scenario, a health plan has contracted with the TPA to provide these links. I think that the group health plan responsibility is to, at least on a monthly basis, when you get the updated link, make sure that they're posted where they need to be posted, and make sure that the information is updated for the current month in which the information is required. Okay, so now I'm gonna move to broker consultant fee disclosures. The Consolidated Appropriations Act amended ERISA to provide that covered service providers must provide certain disclosures to covered plans. And so under the Consolidated Appropriations Act, a covered service provider is a vendor that provides brokerage or consulting services. And we'll talk about more a little bit later about what that means. And a covered service plan is all group health plans, including accepted benefits, retiree-only plans, and grandfathered plans. So this is going to be pretty much any plan that is a group health plan. There aren't exemptions, obviously, for grandfathered plans or small plans. And the disclosures apply to any renewals, any new contracts or renewals or amendments that are entered into on or after December 27th, 2021. So it's important to note that this is a requirement that is currently in place right now for any agreements that are renewed or amended. Okay, so why is this necessary? So stepping back a little, ERISA plan fiduciaries have an obligation to ensure that the fees that the plans pay to providers are not in excess of the work being provided by the providers. And the reason for this is because Section 406 of ERISA contains what is called a prohibited transaction, and essentially it's a prohibited transaction or not allowed for a fiduciary to cause a plan to engage in a transaction if the transaction constitutes a direct or indirect furnishing of goods or service between the plan and a party in interest. So when a plan enters into an agreement with an outside entity to pay them for services, that's generally prohibited under ERISA. However, we have ERISA Section 408, which provides for exemptions if you follow certain rules. And 408B was amended by the Consolidated Appropriations Act to provide that certain service providers, ones that provide consulting or brokerage services, disclose their compensation to covered plans. And the requirements were added directly into the statute, and there have not been any regulations issued, and there likely aren't going to be any regulations issued. However, there was a field assistance bulletin that was released in 2021, at the end of 2021, and provides that if you have a good faith, reasonable interpretation of these disclosure requirements, you can rely on the statute. And also, about 10 years ago, there was a similar requirement for retirement plans. So a lot of brokers and consultants are very aware of those requirements, and there are similar requirements now for group health plans. So who is a covered service provider? essentially the rule requires that no contract or arrangement for services can be between a covered plan or covered service provider without the requirement. And a covered service provider is anyone who reasonably expects to receive $1,000 or more in compensation, whether direct or indirect, pursuant to a contract or arrangement, regardless of whether the services will be performed by the covered service provider or an affiliate. And I think it's important to note that according to the FAB and the statute, that the definition of brokers and consultants is not limited strictly to entities which hold themselves out as brokers and consultants. If you're an entity that is not, that you don't hold yourself out as broker or consultant, but you meet the definition as is written in the statute, you're going to be likely asked to provide these fee disclosure requirements. So it's really important to look at the statute, see if you're an entity that is subject to the statute, and then proceed from there. So who are brokers and consultants? So brokerage services are any services that include assisting in the selection of insurance products, record keeping services, medical management services, administration services, stop loss insurance, PBM services, wellness services, transparency tools, disease management services, EAP or TPA services. So essentially a broker is anyone who is aiding in the selection of these services that are listed. So who are consultants? Consultants include the development or implementation of plan design of insurance or those similar services that are listed under the brokerage definition, including record keeping and PBM services. So whereas brokerage services by definition appear to be assisting in the selection, consulting services deal with the implementation of services. So if you're helping a plan come up with plan design or formularies, those would come under this requirement. So what are the requirements? Plans should be receiving disclosures about direct and indirect compensation from brokers and consultants automatically, reasonably in advance of when the contract is entered into or amended. But what happens if these disclosures are not provided? So first, the plan must make a request to the broker or consultant or the covered service provider to request that the information is provided. If after 90 days there's no disclosure, the plan is actually obligated to report this to the DOL. And then following that, the plan must make a decision about whether they want to continue the relationship. Obviously, this is very harsh. Plans select service providers for a variety of reasons. It's not a short process. It's not easy to simply just terminate a services agreement and find another provider who can provide similar services at the drop of a hat. So I think it's really important for group health plans to be communicating with covered service providers and covered service providers to understand that they're going to be asked to provide this information on a somewhat regular basis going forward whenever there are contract amendments or new contracts entered into. And the reason it's so important for plans to do this is because it's part of their fiduciary duty to ask for these disclosures to make sure that the services that are being provided to the plan that the plan is paying for are commensurate with the services that are being provided. So what actually needs to be disclosed? So I think before I even go into that, I want to talk about the services agreement and recognizing that the services agreement might contain a bit of information that is required under the disclosure, something that you might, you might not need to come up with this from scratch because it's likely already in your services agreement. So I think looking to the services agreement is probably the first step because under this rule, you need to provide a description of the services, a statement that the covered service provider is or is not a fiduciary, or the specific circumstances when they will be acting as a fiduciary, and a description of all direct compensation that the service provider or an affiliate reasonably expects to receive regarding the coverage of the services. And I think those are things that are likely going to be in a services agreement already. But I think the difference here is that there is a requirement to make a disclosure of indirect compensation, and indirect compensation is something that is likely not going to be in the services agreement. So I think that plans and service providers should be having dialogue amongst each other. If there's a service provider that says, we don't accept indirect compensation from any sources, that obviously would be fine, to comply with the requirement. But I think plans are going to be asking about other sources of compensation that aren't coming directly from the plan that are going to the service provider. And then it must also describe the sort of the flow of compensation between the covered service provider and any affiliates, who is getting what. And then it must also include any termination fees. And I think this is important because that speaks to the total amount that's being paid by the plan as a way of determining whether the services are, the amount that's being charged for the services are commensurate with the services being provided themselves. So timing of disclosures. Disclosures are to be made, like I mentioned earlier, reasonably in advance of the date upon which a contract is entered into, and reasonably in advance of the date the contract is extended or renewed. So for example, if you had an agreement that is effective 1/1/2022, that is obviously a few days after when this became in effect, which was December 27, 2021, but you signed the agreement in early December, it wouldn't be subject to these disclosures. But know that going forward, when the contract is extended or renewed, these disclosures are going to be required. If there are changes, the service providers are responsible for providing the information on the changes as soon as practicable, but in no circumstances should it be later than 60 days following the date the service provider becomes aware of the change. And regarding errors, any errors should be corrected as soon as possible, but in no event, no later than 30 days following the date in which the service provider becomes aware of the error. Okay, now I'm going to move to the next two topics. I'm going to just very quickly describe these two: prescription drug reporting. It's not yet a requirement, and that's the same with the price comparison tool that I will also briefly discuss. But while we're talking about transparency, I think it's important to broach these subjects because the requirements are coming very soon. So the Section 204 of Subdivision BB of the Consolidated Appropriations Act requires that certain prescription drug information is to be reported. And the information to be reported is identifying information about the plan, such as the plan year, the number of people who are enrolled in the plan, and each state in which the plan is offered. The information to be provided includes top 50 of the most frequently dispensed drugs, the costliest drugs, and those drugs which have the greatest increase in the previous year. And then also spending by the plan, monthly premiums that are paid both by the employees and by the plan, and then information on rebates and fees and the impact of those rebates and fees on the premiums and out-of-pocket costs. So I just briefly wanted to make everyone aware that aggregation of information is permissible. There was a final rule that was released back in November that provided additional information. I think that's not to avoid getting too granular. I think it's just important to note that the aggregation of information is permitted, although you will need to provide a separate report for each state and each market segment in which the health plan coverage is provided. So due dates. So I said earlier that December 27, 2021, that was the original due date. That obviously has passed. However, implementation FAQ 49 extended the due dates So now the 2020 and 2021 reporting is not going to be due until December 27th, 2022, with subsequent reports being due on June 1st of the year following the year in which the report is created. So June 1st, 2023 will cover the report for 2022. So assistance with reporting, similar to the machine readable files, this information is not going to be available to group health plans. So they're really going to have to lean on their TPAs or their insurers to help them provide this information. So it's important, once again, to reach out to those TPAs and insurers and get something written in place. As you can see on the screen, if you're a fully insured plan, you'll be able to shift the liability, just like the machine readable files. If you're if you're a self-insured plan, you're not going to be able to shift the liability, but it's still very important to reach out and lean on those providers to be able to provide the information. So moving on to the price comparison tool. The price comparison was actually part of the transparency and coverage rules and the Consolidated Appropriations Act. And in the transparency and coverage rule, you're required to provide a tool to allow participants to obtain estimates of costs and compare costs so that, it's transparent where, if they want to compare providers to see where maybe they can find some savings. The information is required to be available by internet or in paper. And as far as timing goes, this is for plan years. For the first plan year beginning on or after January 1st, 2023, there's actually a list of specific items and services in the regulation that lists. There's actually a table, there's 500 services, and those are the services that plans are going to need to provide information on beginning on January 1st, 2023 for calendar year plans. And then the following year, it's going to be all covered items and services. And then finally, the price comparison tool rules in the Consolidated Appropriations Act. That was originally supposed to go into effect on January 1st, 2022, but because there was similar information being required under the transparency and coverage rule, they delayed it until January 1st, 2023. And I think in addition to what is required in the transparency and coverage rule, which requires internet and paper information, you also, under the CAA, be required to provide this information by telephone. So I think that's it. And I think if there are any questions now, we can answer them. I don't know, Kim, if there are any.
Yeah, Mark, I've got a couple questions for you. One is, you mentioned posting a link to those machine readable files, but do employers actually have to reach out and tell their participants about them? Is there any notice requirement other than posting the link?
Yeah, that's a good question. No, there is no notice requirement to provide to participants, and I think the main reason for that is because the information, a lot of information that group health plans need to provide is very much participant specific. Participants need to know such information, whereas these machine readable files, the information, the population that's trying to be reached is not participants. It's these data analysts and it's these researchers that are going to take the information and compile it. It's to let the market know about where there might be inefficiencies or pricing in different locations. So there is no requirement to let participants know.
And another question on that link, are there penalties for not posting the link or for posting it in a way, if it later turns out, because we don't have a public website of our plan, so we post it somewhere else, or we post it on an intranet site. Are there any penalties for not doing this or doing it wrong?
Yeah, there are penalties. I don't recall them specifically off the top of my head. I think that the important thing is that the information be posted publicly. On an intranet website is I don't want to say flagrant, but it's certainly against the rules. So you want to make sure that the information is going to be able to be accessed publicly by anyone who is not associated with a plan who wants to receive the information.
I think we have one last question. If the employer only has insured plans, Do they still need to do anything with respect to the machine readable files?
With respect to the machine readable files, yeah. So if you, it's still an obligation of the plan if they're an insured plan that they need to produce the files. But I think it's important to know that if you contract with your insurer, that they say they're gonna provide the information on your behalf, and something does go wrong, they're either not providing it or they're providing incorrect information, then the plan will not be held liable.
Great, that's all the questions we have at this point.
All right, great. Thanks, Kim. We'll turn to mental health parity. And, you know, this is, I've heard Kim say this before. I feel completely the same. This is sort of the issue that keeps me up at night worried. So we've heard about some of these other requirements. I feel like it's kind of a slow build to the big bad who jumps out of the closet. And we've reached that point. So mental health parity, no one's favorite topic, but I'll try to walk you through it this morning. So background, mental health parity requirements have been around for a while. The first iteration of the mental health parity statute was passed in the actually in the 1990s. And then we had Mental Health Parity and Addiction Equity Act in the 2000s and 2008 that added protections for substance use disorders. Basically, mental health parity is designed to create parity between the medical and surgical benefits that are offered under a plan and the mental health and substance use disorder benefits that are offered under the plan. Plans are not necessarily required to offer mental health or substance use disorder benefits, but it's very rare to find a plan that doesn't offer some form of mental health or substance use disorder coverage. If a plan does offer that coverage, then the plan has to comply with the parity requirements. There are three big categories that are looked at with respect to parity. There's annual or lifetime limits that are applied to benefits, financial requirements and quantitative treatment limitations. Those would be things like the deductibles that are applied, the copays, the co-insurance. Quantitative treatment limitations would be things like number of visit limits. So if the plan says it will cover up to 40 visits per year, that would be a quantitative treatment limitation. And then the third category is non-quantitative treatment limitations. And that is what we're going to focus on today, because that is the focus currently of the DOL and the focus of the new written analysis requirement that was passed as part of the CAA. So what kind of plans does mental health parity apply to? Well, it applies to group health plans. It applies to health insurance issuers who are offering group or individual coverage. It doesn't apply to HIPAA accepted benefit plans. So those would include things like dental only, vision only plans, accepted benefit EAPs. So we're really focused on the major medical and prescription drug plans. Certain small employers are going to be exempt from the requirement, so employers with 50 or fewer employees, and then retiree-only plans that are standalone, only cover retirees, those are going to be exempt as well. As far as, who is responsible for complying with mental health parity, it's ultimately, the responsibility is going to come down to the plan sponsor, whether the plan is fully insured or self-insured. So if we have a fully insured plan, the insurer is going to have some responsibility as well, but the plan sponsor isn't exempt from that responsibility. All right, what are non-quantitative treatment limitations? So I often find that people just can't, it's sometimes difficult to wrap your head around what is even being talked about when we talk about non-quantitative treatment limitations. these are some of the go-to examples and some of the things that the DOL is most focused on. But generally, a non-quantitative treatment limitation is any treatment limitation that isn't expressed in a numerical value. So things like prior authorization and pre-certification requirements. Things like fail first or step therapy protocols. So that's, for example, your doctor has prescribed a certain medication, but your health insurance plan won't provide coverage for that medication until you try a different medication first. And if that medication fails, then the plan will cover the medication that your doctor has prescribed. Other examples, prescription drug formulary design. So even the process of deciding which drugs will be covered under the plan, which drugs will be excluded, that's considered a non-quantitative treatment limitation. So compliance overview, in general, what we're looking at is that the processes, strategies, evidentiary standards, or other factors that are used in applying an Nqtl, that those are applied equally to mental health and substance use disorder benefits as they are to medical surgical benefits. So if a plan is relying on certain authority, for example, to justify applying a non-quantitative treatment limitation like pre-certification to some form of mental health or substance use disorder benefit, are they looking at that same kind of authority when they are deciding whether or not to apply pre-certification to medical surgical benefits? Every non-quantitative treatment limitation has to be analyzed both in writing and as applied. The as applied is increasingly important, as we'll see in a moment when I get to the written analyses requirement. So when looking at Nqtls and comparing the medical surgical to the mental health substance use disorder, we kind of look at things within different categories. And there are certain categories that are permitted or certain classifications that are permitted under the Nqtl guidance. And it's actually not permitted to break things up into smaller classifications like this, except for a few limited exceptions that I won't get into today. But for the most part, we're looking at these classifications. So inpatient in-network, inpatient out-of-network, outpatient in-network, outpatient out-of-network, emergency care, and prescription drugs. Okay, so this is an example of what a non-quantitative treatment limitation, maybe like a red flag analysis would look like. So not a full analysis, but an example of what we might start to look at when looking at these types of Nqtls. So for medical surgical benefits, the plan determines reimbursement rates by reference to the Medicare physician fee schedule. For mental health substance use disorder benefits, then we would also expect that reimbursement rates would be determined comparably by reference to the Medicare physician fee schedule. Any variance in rates applied by the plan, for example, to account for factors such as the nature of the service, the provider type, market dynamics, other issues like provider demand, those types of issues have to be considered in a comparable and applied no more stringently, in a comparable manner and applied no more stringently to mental health and substance use benefits than they are to medical and surgical benefits. So if you're varying the reimbursement rates for mental health and substance use disorder by taking into consideration those factors, and you're not taking into consideration those factors on the medical surgical side, that would be a red flag that you would want to look into further. Okay, penalties and risk of non-compliance. So up until recently, the big issue that we were concerned with when dealing with mental health parity was participant lawsuits. So there have been participant lawsuits for a number of years popping up with respect to mental health parity, but up until a few years ago, we really hadn't seen very significant enforcement action from the DOL, IRS, or other agencies, HHS. That has totally changed, and DOL has been saying for the last couple of years that this is a priority for them. When it comes to health and welfare plans, I would venture to say that this may be their top priority, although I could be wrong on that. But if you gauge it by just the number of webinars that they've given in the last couple of years and the subjects that they've focused on, mental health parity is definitely high up there. So ERISA currently contains no specific penalty or enforcement rule for mental health parity violations. However, there is talk of changing that and adding penalties, so that could be on the horizon. The IRS, however, does impose excise taxes of $100 a day for each individual when there's a failure related to group health plan compliance related to mental health parity. So we have not seen the IRS significantly enforce this penalty. And this penalty is actually something that's supposed to be self-reported by plans each year. So to the extent the plan is not in compliance, the plan sponsor is supposed to self-report that non-compliance via an IRS return. And then you know, that is the basis that the IRS uses to determine whether these excise taxes are owed and potentially negotiate some sort of, you know, settlement with the plan. Because we haven't seen this enforced in the mental health parity arena yet, we don't really have a clear idea as to how the IRS would calculate this penalty in connection with mental health parity failures and what that would look like. So are we looking at, like, if the plan generally is not in compliance with mental health parity, let's say because it has a non-quantitative treatment limitation that is not justifiable, does that mean that we're looking at a $100 a day penalty based on the total number of participants in the plan, even if the, you know, total number of participants weren't trying to access that specific covered benefit? If that's the case, then we could be looking at pretty substantial penalties. And there has been some signaling from the agencies recently that the IRS may start to enforce these penalties. The other big concern continues to be lawsuits. So participants, beneficiaries, the DOL, they can use ERISA civil enforcement provisions to file lawsuits. We've seen, you know, varying degrees of plaintiff success with respect to these lawsuits. In some cases, courts are basically ordering plans to go back and reprocess, you know, a number of claims dating back several years. In other cases, the relief has been prospective, but the big issue here and why these kind of cases are so attractive to plaintiffs' lawyers is because they often involve attorney fee awards. And so these cases can be expensive for employers, and to the extent that employers can mitigate risk to avoid them, that would be best practice. Okay, so moving forward then to 2021, we have the new non-quantitative treatment limitation analysis requirements. Basically, under the CAA, there is a new requirement that plans create and maintain written analyses that essentially justify and explain all of their non-quantitative treatment limitations. I won't go into detail about all of the requirements that go into these written reports, but it is a lot. And it's, you know, information that most plan sponsors are not going to have readily available to them. So this is going to require a lot of coordination and reliance on the TPAs or the insurers, depending on whether you're a self-insured or fully insured plan. The timeline has been really tight from the DOL as far as the time from when they request the written analyses to the time when the plans are supposed to provide these written analyses. So just stepping back a second, so the CAA actually requires the tri-agencies to request at least 20 non-quantitative treatment limitation analyses from plans or issuers each year. What we've seen over the last year, because this has been in force now since February of 2021, what we've seen is that the DOL in particular has far exceeded that 20 number. So over the course of the last year, they requested over 150 non-quantitative treatment limitation analyses. It does appear that they are choosing the plans who they're requesting information from on the basis of past participant complaints. So there's a process by where participants can submit an inquiry or a complaint to the DOL if they think that perhaps their plan is in violation of mental health parity. And the DOL has used those complaints in some instances to prompt further requests for analyses from the plan. We also understand that in some cases, the DOL may have targeted plans because they, the first step was they requested information from TPAs or insurers about what they were doing under their book of business. And then as a result of information that was disclosed during those requests, they learned of certain plans who, for example, might have a blanket ABA therapy exclusion, something that's a huge red flag to the DOL. And so the DOL was targeting those plans. But really the DOL is able to request this information from any plan sponsor at any time. And when the DOL requests this information, there's usually a really tight time frame. So what we've heard is that the DOL is sending out an initial request where they request maybe like analyses for 2 to 3 specific NQTLs that they've identified. And then they tell the plan, okay, you have 10 to 15 days to respond. And when the plan responds, then the DOL, takes a look at that, and then they follow up pretty quickly with a request for the analyses for either a larger number of NQTLs or just all of the NQTLs that are applied under the plan. And then again, they're giving plans a really tight time frame to respond. So again, about 15 days is typical. If the DOL makes an initial determination that the information that was submitted, that the reporting that was submitted just wasn't sufficient, so the reporting didn't include all of the information that the DOL requires to be included in the reporting, then the DOL is going back to the plan sponsors saying, look, this isn't sufficient, here are the insufficiencies, update this report, we want all of that information included, and they're giving them, again, a pretty short time frame to turn that information around. If the DOL gets the report and determines based on the report that the plan actually is not in non-compliance, so the plan, there's enough information for the DOL to determine that the plan actually has applied a non-quantitative treatment limitation in a manner that violates mental health parity. In that case, the plan is required to submit a proposed corrective action. Generally, they're required to submit that corrective action within 45 days. So after the DOL receives that corrective action, if they make a final determination of non-compliance, the plan has to notify covered individuals of that non-compliance within 7 days. This is extremely scary because first of all, notifying participants of non-compliance, no employer wants to do that because it's just bad from an employee relations standpoint. But additionally, this is just, again, throwing up a red flag for those plaintiffs' attorneys. So, it's giving additional fodder to the plaintiff's bar and creating additional risk to the employer that they're going to be subject to some kind of lawsuit. So we did get some guidance mid last year about the Nqtl analysis. ACA FAQs Part 45 provides some additional information about what the DOL is expecting these analyses to look like. It's, again, a little bit vague, but they're expecting the analyses to contain a detailed, written, and reasoned explanation of the specific plan terms and practices at issue. So generic explanations that don't have a lot of detail, the DOL is likely to find those to be insufficient. They're expecting the explanation to include the bases for the plans or the issuer's conclusions that the Nqtl complies. So merely stating that the Nqtl is in compliance is not enough. You have to actually explain the thought process that went into the analysis and why you believe that the Nqtl is in compliance with mental health parity. And oftentimes this is going to require including supporting documentation. So if, for example, when we think back to, those provider reimbursement rates, and to the extent that that perhaps market factors are relied on, what kind of evidence was the plan looking at in focusing on those market factors? And so oftentimes, to support the analysis that was done, the underlying documentation of the resources that were relied on will need to be included. Plans that historically applied, so the DOL years ago issued a self-compliance tool that they update every couple of years. This was issued before these written analyses were required, but if you look at the self-compliance tool, it kind of goes through similar steps as to what is required under the written analyses. And so plans that have carefully applied that tool should be in a strong position to comply. However, candidly, this is not an issue that plans have been really focused on or paid a ton of attention to until the CAA. And so a lot of plans and plan sponsors probably have not, even seen that DOL self-compliance tool, certainly not carefully and in a detailed manner applied that self-compliance tool, but that is a good tool to look at if you're just, pulling your hair out about kind of how to start or how to tackle this Nqtl analysis. The DOL also in that FAQ Part 45 indicated that they've got an expected focus on certain types of Nqtls like prior authorization, concurrent review, standards for provider admission, out-of-network reimbursement rates. But it's important to remember that all Nqtls have to be analyzed, and the DOL can request analysis for any or all Nqtls at any time. The CAA requires the agencies to submit an annual report to Congress. The big issue here is that any plan sponsor who's found to be out of compliance with mental health parity is going to be named in this report. So again, another red flag for plaintiffs' attorneys. So far, based on the first report to Congress, it's clear that we need further guidance. Basically, the DOL issued, as I said, over 150 requests. None of the responses that they received were deemed to be sufficient upon first receipt. And what that says to me is that we don't have sufficient guidance to basically explain to plan sponsors and to consultants and insurers what is expected and what is required for these reports, and how somebody can craft analyses that would be deemed sufficient. Let's see, I'm going to skip ahead because we are short on time. So, top Nqtl analyses requested included things like pre-authorization, network provider admission standards, concurrent care review. But again, important to remember that the DOL can request analyses for all Nqtls applied under the plan at any time. Okay, so the big picture, lessons for plan advisors. Preparation is key. You're going to want to be talking to your plan sponsor clients about this, so that they're not waiting to get a DOL request to start reviewing mental health parity compliance. What we know from the guidance that we've heard from the report that was submitted to Congress this year is that plan sponsors who have waited for that DOL request and didn't really do anything prior to that DOL request, they're already viewed as in non-compliance, because the DOL is expecting plan sponsors to have done these analyses already, to have these analyses in place. In fact, the DOL, said in their report that one of the problems that they've seen is that plan sponsors didn't do the Nqtl analysis when they first implemented the Nqtl, which I found that to be surprising, given that in many cases, Nqtls have been in place for a number of years, and this requirement wasn't even necessarily applicable at the time that the Nqtl was implemented. But, big picture, if the plan is waiting until it gets this request, the plan is already out of compliance. Cooperation of TPAs and insurers is necessary, and oftentimes as the broker, you're going to be acting as a go-between, between the plan and that TPA or the insurer. Plan sponsors have to take an active role in requesting and reviewing the analyses. What we've seen, what's starting to become standard practice is that, especially with respect to self-insured plans, the TPAs aren't going to do these analyses for the plan sponsor. What the TPA will do in most cases is provide you with a standard Nqtl analysis that they've done for the standard Nqtls that they apply across their book of business. Based on what we've seen from various TPAs, the analysis that you're getting to start with is it's to varying degrees of compliance with what would be expected. So generally, I would say what you're going to get first from the TPA is not going to be compliant. You're going to have to push, you're going to have to request, as applied analyses. You're going to have to request cooperation in determining if the plan is applying any non-standard, non-quantitative treatment limitations, so that you can review those as well. And then you can always do a red flag review. The self-compliance tool is really helpful in doing that kind of review, but you can do a red flag review just by sort of going through the benefit booklets. There are certain Nqtls that are just highly likely to be non-compliant, like an ABA therapy exclusion, blanket pre-certification requirements for all mental health or substance use disorder benefits. So certain things that are called out in the self-compliance tool and in some of the other guidance, those are, if you see them in your plan or in your client's plan, it's time to think about, maybe we want to change the plan design with respect to that item. All right, and so we are expecting more guidance later this year, including updates to the self-compliance tool, another report to Congress, and proposed rules implementing the CAA. All right, so we have just a couple minutes left. Kim, any questions that have come through?
If an employer has fully insured plans, is there anything they can do to sort of shift the liability for these Nqtl analyses to the insurance company?
Yeah, so unlike the case with the machine readable files, for example, this isn't really a situation where, at least statutorily, you can shift liability. Now, an employer can, potentially try to contract with the insurer that the insurer will indemnify the employer against any damages or losses related to Nqtl or mental health parity non-compliance, but thus far I've not seen insurers really be willing to entertain that.
And you mentioned a couple of really tight timelines for responding to the DOL.
Yeah.
Have you seen the DOL give any, extensions or grace on taking more time?
Yeah, so the DOL has been really strict on this. So, in some cases they might give an extension, but it's going to be a really limited extension. So maybe another 10 days or another 15 days. But they generally have not been willing to give significant extensions of time.
And then we have one more question that actually goes back to Mark in our last minute here.
Okay.
For those obligations that you can shift liability to the insurance company, how do you do that? How do you contract with that insurer?
Well, I think you can enter into either amending your services agreement to list that that's a service that they're going to provide. I think that might be the easiest route to go. Or you could, just separately enter into an agreement where they're agreeing to provide services.
So in most cases where the employer just has an insurance policy and there's no services agreement with the insurer, you're saying the employer should develop maybe a separate contract, like a one-pager or something like that?
I think that, yeah, sorry to cut you off, but yeah, I think that would be definitely a good idea.
Great. All right, that's all the questions that have come in so far.
Thanks, Kim, and thank you, Mark, for presenting with me today. Thanks to our colleagues at Professional Group Plans and to all of you for attending our webinar. If you do have any questions that we weren't able to cover today, please feel free to reach out to us at Thompson Hine or to Professional Group Plans. Thank you again very much for attending, and please enjoy the rest of your day.